hearing. Go ahead and get a copy of today's order at the window. That way, outside the courtroom. And wish you the best of luck. You take care. If you don't have to come back on the 30th, go ahead and get a copy of today's order at the window. Take care. That way.
It's going live.
Stefan Norton is not in the courtroom. My understanding that he did show up on Zoom. He was specifically ordered by both treatment provider and myself to be here in person. I'm not going to accept the Zoom call if city has no objection. Tyler Sorensen. Tyler, good morning. How are you? I think so far so good is the best thing. Anything new since we were last in session?
Yeah, the last one I was in the Superior Court. They're giving me some more time to switch my insurance now because I'm about to lose it anyways, but it should open a lot more options for me for treatment. But the only thing about it is they're gonna hold a sanction over my head to do a month if by I think the 11th of next month when I come in that I'll have to serve a sanction if I'm not in a class yet.
You look at it a 1 month sanction, and that's out of Thurston County?
Yeah, Superior.
The Mr. Redfield, my industrious clerk was good enough to prepare kind of a history of this thing. This was a 2-year SOC entered into on July 20th of 2023. To look over the history of the thing and perhaps been kind of a long haul here.
Yeah. I've been trying.
And the sanction with the county, the 30 days was for what?
It's so like I can change my insurance and get into a class before then. And as long as if I'm in a class before that, the day I have to go back to court, then I'll be good. But if I don't get in a class, then I'll have to serve a 30 days.
Now, what is the charge there?
It was for treatment too.
The original criminal charge, a DUI?
No.
What was that?
It was for the first jail offense that I've had.
And that was, what was the offense?
It's assault 4 and I think speeding is all it is now.
Are you on for how long are you going to be on probation with county?
They don't have me on diversion. They had me on diversion at first, but they said as long as I continue doing what I'm doing, then I should be okay. And then they're going to drop the charges if I can get into a class before then and get the class completed.
It's time to set the ratification.
You know, you actually have until the 20th of this month, I guess. That's what we're going to do is set the matter for a revocation hearing on the after the 20th, on the 31st. It might be better to just, you know, they conclude the matter and quit struggling with us and deal with your problems on the county level.
Yeah.
That would result in a conviction for DUI, but they will cross that bridge when we get there. You were represented by Mr. Haverco. You're entitled to have him here. Do you want him here for the hearing on the 31st?
Yeah.
We better set that then for 10 a.m. Oh, it's been kind of a long haul. It's been a struggle. It's my hope that at some point you're gonna turn a corner in life and things will overall go in a more positive direction. That's all I can hope for. Sign the order. Go ahead and get a copy of it at the window outside, and we'll readdress the matter on the 31st. Take care of yourself.
Okay.
Be well.
Thank you.
Thank you. Serena Villegas. Tina Wells is here. For the record, is it Tina Monique Wells?
That's my middle name.
It looks like you're in partial compliance,
Yeah.
but we need a victim impact
know.
panel. Any progress being made on scheduling that?
Yeah, I realized that it's kind of hard when I don't have my own car and my family's busy all the time. And I tried calling all of those lines and they were, I guess, they're always seem to be busy. So I'm just still trying to find somewhere.
I do not see any indication of any reoffense or any problems. Life is going well for you. That's as well as what I think I want to do is reset the matter to August 14th, give you a little time. The most important thing is you're not in trouble. You're
Right.
not getting in trouble. You just haven't jumped through the
Yeah.
hoops you have.
Mhm.
The victim impact panel is hopefully something you'll learn from and help keep you from reoffending, okay?
Yeah.
As well as I've signed the today's order. I want you to get a copy of that at the counter and again, if we have the proof on file, by the time you get here, you don't need to reappear. But if you
Okay.
think, yeah, if you've done the class and
Like the victims
yes,
pamphlet class? Okay, yeah,
maybe you may want to call us and make sure that you have the proof on file, okay?
right.
Good luck to you, Ms. Wells. The most important thing is don't reoffend, stay out of trouble.
Yeah. Thank
Good luck to you. Again, get a copy of the order at the window. Mr. Redfield, I guess we can deal with the no-shows later.
Yeah, I agree.
Give people a little time.
There's a few ones that-
I suspect that's the case. Parties ready to proceed and call the matter Yelm versus Renberg. If they're ready. And with that, we can go back on record. We were on. Mr. Ellington, good morning. You're the moving party. I'll hear from you.
Good morning, Your Honor. Thomas Ellington for the record with Mr. Burnham. Your Honor, at the court's request, we filed an addendum evaluation that addresses all of the concerns that the court had, specifically the mental health aspect, the alcohol aspect, defining what the treatment plan was. The treatment plan is now defined in the program. It's basically once a week for a year. And he has an AA group ready to go as soon as he's released. He has housing secured starting tonight for a hotel for 10 days. He also has an apartment complex that he's lined up to rent and live. And so he understands that the court will impose conditions, which include no consumption of alcohol, random UAs, comply with treatment, and he's ready to start all of that immediately.
Mr. Redfield.
Your Honor, the city's position hasn't changed since prior hearings. City's wanting to see this sentence. Don't anything has changed since the original sentence.
I can't hear anything you're saying, sir. Could you speak up, please?
We don't believe anything has changed since the original sentencing. We'd like to see that sentence fulfilled.
Problematic nature of this type of case was I was reminded of this morning on the way down here on the local news. The King County assessor is back in jail on a stalking charge. That's been in the news for a little while, rather publicly. Her matter, Mr. Ellington, you may be familiar with the case. The fellow running for King County executive. Two sides to that story. I'm sure we'll hear more about that in the future. Mr. Burnham, is there anything you'd like to tell me? With your attorney's permission, if there's anything you want me to know.
I didn't really catch what all was said, Your Honor. I'm sorry.
Okay, Mr. Ratfield denied, opposed to your petition to have remaining jail time suspended.
Well, because I don't think he knows me as a person. He doesn't know what I've been through for the last 8 months while I've been in jail. He doesn't know what my plans are for the future. That to get my life back on track. And to go back to volunteering in the community like I've been doing with American Legion and the Senior Center. Those are things that I do that are positive that haven't been brought up in this whole process. There's positive things that I've done that I do that have not been brought up. It's all been negative. I've done some bad things. Yes, I have.
You're not helping yourself. You're not helping yourself at all.
Your Honor, he does. He does have a desire to get back to his normal life, which includes life with his kids, seeing his family members, doing his volunteer work. He recently contributed $1,000 towards the Little League baseball field as a goodwill gesture towards the community. He does take an active role in the city of Yelm, in the community of Yelm, and has lived here a long time and is wants to be a part of that community. And so he understands that he's got a lot of hoops to jump through, a lot of treatment requirements, and they're going to be strict. It's going to require strict compliance. He knows that if he consumes alcohol, he probably goes straight back to jail. He knows that if he violates any of the court's orders, he knows he goes straight back to jail. He knows that his previous marriage is over. He knows that he's going to have no contact with his ex-wife, that he's going to abide by that court order. And he knows that zero means zero, absolutely zero, nothing. He learned the hard way. One of his violation orders was being within 1,000 feet of the place, trying to figure out how to get his mail. And that alone violated him. So he knows how easy it is to get violated. He did have 2 situations during release where he went to the Walmart store. He saw the car, the vehicle that belongs to his ex-wife. He recognizes that car. It's distinguishable. As soon as he saw that car, he immediately turned around and left, went back later that day. That happened twice after the incident. And so he is keenly aware of staying away, abiding by the court's orders, and complying with all the court's conditions. He is frustrated, as the court can pick up on. He's served 8 months, over 8 months in jail, a long time. Feels like he has served long enough that it's got his attention in a big way. And he wants the opportunity to prove himself worthy to the court, to the community, to himself, to his family, to his children, to his friends, and be a more productive member of society.
Mr. Burnham, do you disagree with anything at all that your attorney just said?
I have nothing, Your Honor, I'm sorry.
Do you agree with everything I just said?
Absolutely, yes.
And you were able to hear it?
Yes, Your Honor.
You know, the easiest thing for me to do is just let you sit out your time in jail. That'd be the easiest thing. But out the end of 2 years, you would be out. If I go the more difficult way, that I would still have a handle on you that I would not have if you just served out your time. What I'm going to do is this. I'm going to give you credit for, my mathematics is subject to review, 252 days served, resuspend 112, that's on count one. On the second charge, 364 remain in effect. Conditions of release are full compliance with the domestic violence recommendations made in the addendum 2 and in the original evaluation prepared by DV. There's going to be 100% compliance with the no contact order. The burden is on you. If I'm not going to believe in any coincidental contact, any contact at all, I'm going to assume that that's in violation of the order. Maintain a current address with the court. I also want you to complete a drug and alcohol assessment and comply with any recommended treatments. I assume that will be a relapse prevention. I did have a chance since our last hearing to go over the initial evaluation and a couple of things jumped out on me. And the stalking charge and the use of a weapon was committed while you were under the influence of alcohol. But you do now appear to have an understanding of the dire need to continue to do all things to remain sober. The evaluation also indicated that you'd been through 8 over the years, different inpatient and outpatient treatment programs. That simply illustrates the problem as an alcoholic is an alcoholic. You can either be a drinking one or a non-drinking one. You've got to be a non-drinking one. One drink, I think, and you're right back to where you were in an earlier situation. I'm going to set a review hearing for July 31st. I want you here and I want to hear Mr. Ellington, if that works with your schedule.
Yeah, I'm looking right now, July 31, yes, at what time? 8:30?
8:30.
That works.
I want proof of the completion of the drug and alcohol evaluation within 30 days. I think you've done a great job, and your attorney has on your behalf in obtaining the DV evaluations and the follow-up to that. I realize I am fully cognizant, I should say, that in the recommendations in the first evaluation, it is critical that Mr. Burnham continue to support his sobriety. And it ends with the sentence, Mr. Burnham's future success at remaining out of the legal system absolutely depends on Mr. Burnham's capacity to remain substance-free. That, I think, is absolutely critical. That's the key component of the matter here is substance. Any questions? I'm looking at the amended JNS. O courts, that's one of the problems I've always had with the computers is they tell us what to do and we don't tell them what to do. There's no real provision to do an amended JNS. In here, I want the parties to review. Johnny, did you have access to that?
No, there's nothing here.
Yeah.
Oh, yeah. you can
Yes.
edit it
Oh, yeah.
too.
I started at the beginning.
Yeah, and so it starts right here, just want to make sure that I.
12 and then 364. Yeah, that's
So,
right.
Should I mark?
No.
Is it being released? Should I mark that then? Or what is it? Right? So we have to
Yes,
edit.
yes, okay.
Got it.
Uh,
I wrote it down. It's too late.
Yes, do that, and I assume there's one in that other one too.
Right, we'll do this. Oh, completely.
Yeah, I wish I could look at the whole thing, it's July 30 is the review area there.
Oh, yes, it's at the very top.
It looks good.
Higher.
You can, you can sign for me or I'll authorize it.
It,
I can
I
sign.
tried changing the time, it didn't let me, but we can make sure that it is at 8:30.
Yes.
So
That's fine.
Jana, it does say 9 AM, but that's what the computer makes us put in there. It'll be 8:30.
I wrote down 8:30 and I reviewed the amended order. It looks fine, Your Honor. And I authorized my signature to be electronically added.
And again, my mathematics with regard to time are subject to review and amendment should that become an issue.
That's fine. Your Honor, I'm not asking to change the July 30 date for the alcohol eval, but from practice with the holiday this week, it's going to be tight. But we'll do our best to get it
I'm not
done.
gonna hold you to that then. No, I forgot, yeah, 4th of July.
So I'm just sharing with the court, we'll do our best, but I'm saying that's a pretty tight deadline to get an eval done nowadays.
Do what you can.
Okay,
Mr. Burnham, I realize I'm taking a chance here. A lot of judges have had to live with the results of taking a chance and finding out that it was the wrong one. I could tell you a few stories about that. I'm sure the other lawyers in the courtroom could do the same. Don't add this to the burdens I carry, okay? It's up to you.
he doesn't want you to make a mistake and make him look bad in the future by doing something stupid. You got that? Okay.
You've got a lot of suspended jail time. I would impose that in a minute if there's a step off the path here. Hey, Mr. Burnham, good luck.
Thank you, Your Honor. I'll wait for the clerk for an
Get a
order.
copy of that at the,
Lets you edit. Because once you signed it, okay, go up. We didn't select the release portion and the jail won't need it.
it's down here.
Yeah, that's right there. That's the only one. Let's see.
There's usually one
Yeah, there's usually
for
two.
two.
Right.
Maybe
Maybe it's a little bit higher up for the first one. I think we may have done the first charge and yeah, we're now moving into the second charge. Oh, right there,
not.
please.
There we go. That's-
Yeah. It only lets you edit it because you're.
Oh,
beside it.
that's
So
right.
Now you can save it.
Save.
Now I can print it.
Very good. Save. Okay, great.
Perfect.
We'll take a brief break. Consider it about, we don't have anybody that's tell her no reason, yeah, go off record. So yeah, we're waiting for Dan pretty much, and for privates. Back on record for the 8:15, no shows, starting with Amador Contreras. Discharged from treatment on a DUI.
Your Honor, the state of New issued, 20.
So ordered. Peggy Inkhorn, just one of these SOCs, money, money.
The city's not gonna take any action.
Want to just close the case, dismiss it. It's, dismiss and close. Benefit of the doubt. Kelly Kincaid, that's some MIP, minor possession, consumption. Couple of new violations,
Yeah, 500.
500 cash or bond. So ordered. Selena Menish was here. Mr. Norton is not here.
It's,
And apparently he's the one with the 2 warrants in other courts. He still hasn't done anything about
No.
that. It's a warrantal issue, 1,000 cash or bond. Serena Villegas. Treat,
200.
so ordered. He said 50 cents. I got a couple of quarters right here. Let's wait. Let's go on record. Back on record for the 9 o'clock. I'm going to defer to Mr. Ratfield for the and Defense Counsel for the order in which the cases are called.
Good morning, Your Honor. Abigail Pence. This is Mr. Golden. And this is 5A02324446. We are asking the court to accept the plea of guilty as charged to 1 count of DUI.
And this is
Mr. Kevin Golden.
Didn't catch the name?
Kevin Golden. Golden is the last name.
I'm looking at the wrong. Good morning, sir. Full name Kevin Alton Golden. Yes. Defer to your counsel.
And good morning again, Abigail Pence for Mr. Golden. I have reviewed this guilty plea with Mr. Golden. I do believe he's entering the plea today knowingly, intelligently, and voluntarily. We've discussed all the collateral consequences of the plea. We've discussed immigration consequences. We've discussed all of the rights that he waives by entering a plea of guilty today. We would ask the court to accept this plea and proceed with sentencing this morning.
Mr. Golden, do you disagree with anything your attorney just said?
Yes, sir.
I'm looking at a statement of defendant on plea of guilty to 1 count of DUI, driving while under the influence of intoxicants. Plea form tells me you're 39 years of age, been through high school. Any issues at all reading, understanding the English language?
No, sir.
Have you gone over the plea process and the language in it with your attorney? If I accept the plea, you've given up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 364 days in jail. This, given that this is a gross misdemeanor. Also bears the possibility of up to a $5,000 fine. If I accept the plea, Department of Licensing will take action against your driver's license, and such an action is dictated by your previous history. That in mind is to 1 count of driving while under the influence of intoxicants within the city of Yelm on February 15th, 2025. How do you plead? Guilty or not guilty?
Guilty.
Do you make that plea of your own free will?
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. With regard to a recommended sentence for Mr. Golden, here from the city.
We just asked that you.
Good morning again. We would ask the court to follow this recommendation. I believe it's an appropriate recommendation. The court can see that Mr. Golden does have some prior DUI history. He actually completed successfully a deferred prosecution many years ago. So he does very well under supervision by the court. Part of the recommendation that we're making today is based on the fact Mr. Golden does have over 5 months now, right? Treatment. He's been in treatment for 5 months now. We filed the completion, or not completion, but compliance reports for that treatment that he's completed. And so he's doing very well at this moment in treatment, doing well moving forward from this incident. He did back in 2018, 1 year in custody on a Superior Court DUI. And so he does take this very seriously. He understands, you know, that the recommendation for this court could be a lot more serious. We are hopeful that the court would follow this recommendation, which essentially leaves about 17 days left to serve in custody. And we are asking the court to authorize his opportunity to participate in the work release program at Nisqually Jail for the balance of the jail time that he has left to serve. Part of his recommendation as well is asking the court to authorize the 120 days of SCRAM in lieu of the 60 days of EHM as an alternative. He has done 123 days pretrial and has had no alcohol violations in that entire time. And so we'd ask the court to consider granting him pretrial credit for that and removing him from the SCRAM device today. And we would ask the court for approximately a report to jail date in about 30 days so he can arrange with work and make sure that that's all lined up prior to reporting to jail for the balance of the jail time to serve on this.
Is the mandatory minimum 30 in this
It is.
situation?
He has 1 prior within the last 7 years. He does have 3 prior offenses, but only 1 within the last 7. So the mandatory minimum as calculated would be 30 days in custody, 60 days of BHM, or 120 on alcohol monitoring.
Mr. Golden, you don't have to say anything, but if you want me to know anything about your situation, now's the time.
The biggest amendment they can make is behavior and
You know, it's a little on the fortunate side that you're here, but with the history you have, a lot of people with a similar history are incarcerated in a penitentiary because of having done something really bad while drinking and driving, or are simply no longer here at all. They've passed on. I'm going to follow the recommendation, 364 days in jail, 334 suspended, credit or 30 days to be served, and they be served as it's indicated. Give you credit for the 10 days you've served. And you can do 100 days on scram. You've done that. I take it. How much time does that leave to be served in the?
I believe my calculation is, well, so it leaves 20, he has 10 days of credit, so it leaves 20 days to serve, but we had discussed the fact that he's eligible for good time at Nisqually jail. That might be less, but 20 days to serve would be the commit to jail for Nisqually. And I believe Nisqually, last time I had him eligible for work release, they need some particular language in the commit to jail, I know, document to allow them to participate in work release on the commit to jail. Otherwise they won't screen them.
Work release comes and goes at the jail. I'm not sure where they are right now on it. They may have it, they may not. I'm not sure. Anyway, I'm going to follow that recommendation. The remaining 20 days to be served, give you credit for the time served, and they may be started within the next 30 days, 20 days, to be served within the next 30 days, started within the next 30 days. Mr. Golden, the conditions of the suspended sentence are drug and alcohol evaluation, comply with any recommended treatment, that to be done within the next 90 days, get that done. Pointed out to me earlier, this is the busy season. Tomorrow's the 4th. The alcohol treatment agencies are going to be very, very busy here for a while. This may take a while.
We filed proof actually earlier this morning. You may not have seen it yet, but we sent an email with proof of his evaluation. So he's already done his evaluation and he's already done treatment for about 5 months. So
Perfect.
He's well on his way in treatment. And his anticipated completion date is December of 2025. So he's got a few more months and he's had all compliance. So
Perfect. I haven't looked at the file. I'm going to take your word for that. That's Mr. Golden, continue to fight the good fight. Don't give up on yourself. You're here now, you're healthy, you're doing well, doing treatment. How's that going for you? That's hey, sometimes we have to get hit over the head more than once to learn to modify behavior. I'm just going to wish you the best of luck. Take care of yourself. And of course, a lot of suspended jail time hanging over your head for 5 years, jurisdiction that we have. That's and big condition is no reoffenses, no alcohol related driving offenses. It takes longer to do this in O courts than just putting a signature on something. I forgot to mention the mandatory fine, which is $1,256 even. That can be paid at $100 a month. So that's mandatory. I don't have any really choice in that. That's the least of my concerns here. My major concern is sobriety. That's and no further offenses. If it becomes difficult to make any fine payments, just simply let us know or have your attorney let us know. We can certainly deal with that one way or the other. I hate these fill in the blanks one. Donnie, in the JNS form, is there a blank with the community work release authorized?
Down, if you scroll down, I put it in the other box because there's not really a
Oh,
spot that
okay.
I saw. Further. Yeah, so right in
Okay,
here,
good.
kind of added the extra stuff that doesn't really have a fill in the blank.
Okay, got it.
If anything needs to be
Got
edited, you
it.
can just type in there.
Signing the judgment and sentence in open court. And it does reflect that work release is authorized,
Thank you.
if available, if available. Mr. Golden, again, good luck. Take care of yourself, be well, and stick with the treatment. I'm sure they've told you by now, hey, problem never goes away. It just has to be dealt with. That's all. Copy of today's paperwork you can get at the window outside the courtroom to your left. And again, I wish you the best of luck. Take care of yourself. Your attorney has done an excellent job, and the resolution you have here. There's a lot of other courts, so I won't go any further than to say things could have gone real bad. Good luck to you, sir. Take care of yourself.
Yeah.
Thank you, ma'am. Radfield, the next. Do you want me to just call through the calendar? Deanna McLeod. We can certainly call that. Mr. Van Vechten, good morning. Ms. McLeod, good morning. Hear no objection?
No objection.
Mr. McLeod, I'm signing, and is it with or without prejudice? Without prejudice, your attorney will tell you that means that city is free to refile. That rarely happens. In fact, I don't think I've ever seen it happen, but that's a possibility. I'm going to wish you the best of luck. There's no such thing as a perfect relationship. There's speed bumps on the road of any relationship. I'm going to wish you the best of luck in the future and resolving any issues you have. Any questions? Order is dismissed. Order of dismissal is signed. You can get a copy of that at the window if you want on the way out of the courtroom.
Thank you, Your Honor.
Van Vechten, I think you have another matter on the calendar, do you? Kinsey DeFord in the courtroom?
So, Your Honor, may recall that.
Deanna, good to see you.
5 minutes.
Your Honor,
Mr. DeFord does not answer. Go ahead.
No, Your Honor, may recall that this court is now the subject of adult guardianship program in Spokane. It was supposed to last for many months. I asked for an extensive set over, I think it was 5 months. Your Honor, what happened? So yesterday I called. It turned out that after 30 days in Spokane, he was transferred to Royal Life Center. And had I known that sooner, I might be able to make his appearance possible here, although I can't say what. But I can say that it still is a program that progress has been made. I've spoken to him on the phone, speaking with more clarity. But there has been a relapse. Last time, so I think we would say he's 30, 60 days clean now. Very, very frustrating. This is got one of the more intense levels of addiction. Hey, runner.
How far would you like to go?
Another 60 days off.
See, you have any objection?
No.
September 11th? 911? I think something had noticed. Get a copy of the notice at the window and a copy of the notice will be mailed to Mr. DeFord at the last address we have for him. Whether that gets to him or not, I don't know. Mr. Van Vechten, thank you. You take care.
The call number 2 in the calendar, matter of.
Olivia Cavins. Olivia Cavins, good morning. Full name Olivia, no middle name Cavins.
Yes.
Morning. I'm looking to no courts at an order. I'll hear from counsel.
Your Honor, seems to be dismissed.
I hear no objection. Ms. Cavins, that's by far the best resolution you can get in a criminal matter is have simply the matter dismissed. I'm going to wish you the best of luck. I do remember the probable cause statement in the case filed, and hopefully things are looking up for you, are doing well. Signing the order as we speak, is it with or without? And as I said a moment ago, without means there is the possibility that they could, upon further evidence or reconsideration, refile the matter. I don't think I've ever seen that done, but the possibility remains. Any questions at all?
No, Your Honor.
Get a copy of the order at the window outside the courtroom to your left. Ms. Cavins, I'm going to wish you the best of luck. Your attorney did a good job in resolving the matter in a favorable way. Take care of yourself. Thank you, sir. No other counsel in the courtroom. Do we have any attorneys on the on Zoom? Well, the matter of Yelm versus Robert Meadows. Mr. Narlock, good morning. We'll take your matter now. Mr. Meadows is in the courtroom, seated at the council table. Good morning.
So, Your Honor, we actually unfortunately, there was just some delay, but we just got the evaluation for Mr. Meadows, and I just wanted to discuss it with Mr. Ratfield. So we're just asking to roll this to the end of the month. It looked like the 31st was available so that Mr. Ratfield and I can discuss possible resolution.
City has no objection. Mr. Meadows, at the request of your attorney and yourself, we're resetting the matter to July 31st, 9 o'clock. I am citing an order to that effect as we speak. What I want you to do when you leave the courtroom is get a copy of the order at the window. Any conditions released earlier set remain in effect, and stay in touch with your attorney, okay? Any questions?
No, sir.
Mr. Narlock, any questions? Matters reset. We'll be sending you a copy of of today's order. Take care.
Thank you, Judge. Thank you, Judge. You too.
Who do we have? Who that's for? Garrett, do you know who that's?
Yeah, let me double check. You said. Wait, what number did you say?
Mr. Chairman, good morning. You're here on behalf of who?
I'm here on the raise matter, Your Honor. Sorry about that. Somehow the login I had wasn't letting me communicate with the court.
You're on behalf of Fernando Reyes?
That is correct, Your Honor. We're asking for his appearance to be covered by counsel pursuant to CR 3.4, and we're asking for a continuance of the matter to September 11th of 2025. I don't believe the state has an objection, but I don't know that for sure.
No objection.
Hearing no objection, I'm signing an order resetting the matter to 9 a.m. on September 11th. We'll be sending counsel of record a copy of today's order, and we'll be sending a copy to the last known address of Mr. Reyes as well.
Thank you. And Your Honor, just for completeness of the record, I am Steve Trennan with Puget Law Group, and I'm covering on behalf of my colleague Shannon Pauly.
Okay, great.
Thank you, Your Honor. May I be excused?
Absolutely. Mr. Trennan, thank you for appearing. Take care. Have a
Thank
good
you. You too.
There we go. Sean Huppert.
Good morning, Your Honor.
Mr. Huppert, good morning. You're here on behalf of who?
Michael Wilson.
Mr. Wilson?
My understanding Mr. Wilson is present on the Zoom.
Oh, he is. He just disappeared on my screen. Mr.
Oh,
Wilson,
there is.
you're muted. If you'd unmute yourself, we're going to take your matter at this time.
Yes, Your Honor, I'm here.
Good morning.
Good morning.
Full name, Michael Ray Wilson.
Yes.
Turn to your attorney for the status of the matter.
Yes.
Yes.
Mr. Huppert, go ahead.
Okay. Your Honor, we're requesting a set over continuance. We filed a speedy trial waiver, and the reason is we just got the discovery yesterday, so we want to review that with our Mr. Wilson and come back and see if we can't resolve this.
Mr. Wilson, at the request of yourself and your attorney, we're resetting the matter to August 14th at 9 a.m. In the meantime, any conditions of release earlier set remain in effect, and stay in touch with your attorney, okay?
Yes, Your Honor.
Any questions at all?
No.
Mr. Huppert, any questions?
No, thank you, Your Honor.
We'll be sending Mr. Wilson and yourself a copy of today's order. You take care.
Appreciate
Thank
that,
you.
everybody. Have a great weekend. Bye.
See you in August. And we have Dominic Bueno. There's a motion. Hey, good morning. Go ahead and have a seat, Mr. Bueno. Is your attorney, Ms. Langley?
Your Honor, she had an emergency that she made me aware of, so I would like to ask for a continuance until she's available.
Any idea how long she's gonna be?
I am not sure. She told me she would be in Olympia this morning. She did make me aware that she sent over some documents and paperwork over to the prosecution office, and also let me be aware that she did have an emergency this morning in Olympia.
It looks like there's an order resetting the matter to July 17th.
Yes, Your Honor. Miss Langley and I have been in good contact. we discussed the conflict
No problem.
as recently as yesterday afternoon. Unfortunately, it was just unavoidable. And so while we did discuss a continuance, didn't pin down a date, but I don't, we've been in good contact, so I don't believe anything beyond July 17th will even be needed.
Mr. Bueno, we're resetting the matter to July 17th, 9 o'clock. That's 2 weeks from now. What I want you to do is get a copy of today's order at the window. And hey, a good lawyer is a busy one, and these things happen. That's just the way the practice of law goes. So I'm sure Ms. Langley doing the best she can to resolve the matter. Go ahead and get a copy of today's order, and we'll see you back here in a couple of weeks.
Acknowledge, sir. Thank you.
Hey, take care of yourself. And we'll be sending Ms. Langley a copy of today's order as well.
Acknowledge. Thank you.
Take care of yourself. And I think
I think I got halfway through putting together that our motion. Yeah. Okay.
you got it. We usually hear from Mr. Harbison, but Garrett, do you know anything about docket number 6?
No, but let me just confirm I haven't received anything. No.
I think as a matter of courtessy, maybe note the non-appearance for speedy trial purposes.
Oh, absolutely.
And
Yeah.
reset out 2 weeks maybe.
Yeah.
Note the non-appearance of Mr. Edwards for speedy trial purposes. We'll reset the matter to the 17th of July and send a copy to both Mr. Edwards and Mr. Harbison. I think a simple notice would Back on the record, should we address the warrant quash calendar?
Yeah.
I'll defer to the parties.
Yeah, let me just turn to that.
Mr. Fenton, why don't we take you first? Come on up and have a seat next to Mr. Is your full name Stephen Raymond Fenton? Mr. Fenton, you heard of an arraignment. You were cited on May 23rd, 2021 of attempted theft in the third degree, which is a gross misdemeanor with a maximum penalty of 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverko to represent you at this hearing, and he will represent you throughout the course of the case if you're indigent and request his services.
Stipulate to probable cause, Your Honor, ask the court to enter or not guilty plea.
Mr. Fenton, exchange contact information. You're going to get an order resetting the matter to August 14th at 10 o'clock. And it'll have Mr. Haverko's contact information on that order, but he'll need to have your contact information at this time.
Couple things. Sign here first. And then I'll be coming.
Mr. Fenton, conditions release, law-abiding behavior. Stay in touch with Mr. Haverko, and we'll see you back here August 14th. Thank you for your patience. Take care. Mr. Valdez. Good afternoon, sir. Full name Victor J. Valdez.
Yes, sir.
Mr. Valdez, the citation issued to you was on June 3rd, 2025, and was for theft in the third degree. Again, a gross misdemeanor with a maximum penalty of 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverko to enter a plea on your behalf, and he's going to represent you throughout the matter should you be indigent and desire his services.
Stipulate to probable cause, Your Honor, ask the court to enter or not guilty plea.
Plea of not guilty preserves your rights pending a pretrial. That'll give you a chance to talk to Mr. Haverko about the matter and decide how to proceed.
What's it about? 5088.
And for the record, is Jeremy Crahan in the courtroom? He is not. How about Albert Phillips? Mr. Phillips is in the courtroom. No, hold on, we'll take you next. Hold on.
Okay. Yeah, before you go, to stop by the clerk's office, and she'll give you a printed out copy of everything today. And I'll be giving you. Yep. And I think we also had on the 9:45 calendar, I believe, Albert.
Mr. Phillips is in the courtroom.
Phillips is here.
Mr. Phillips, come on up and have a seat. For the record, Albert, middle initial X, Phillips. Mr. Phillips, you missed a pretrial hearing. I assume that by now what we're going to do is reset the matter. Mr. Haverko still represents you. Thank you for appearing.
Let me reconfirm your contact info. You have a phone number? What is it?
So you're simply going to get a notice of hearing. Mr. Phillips, next court date is August 14th at 11 in the morning. Conditions release, law-abiding behavior, stay out of trouble, and show up.
And,
that's all.
Sign here. Yeah. That's good. Yeah, that's okay.
Mr. Phillips, thank you for appearing. Get a copy of today's notice at the window, and see you here in August. Take care of yourself. And same to you. Take care. Mr. Haverko, I think we have one gentleman in court who has a bit of a situation going. And Crahan, yeah, let's just strike that. Give me a second here. Okay. Reissue a warrant. If that was quashed, reissue the warrants, same bail amount for Mr. Crahan.
Go ahead and sign here.
And this is?
This is Matthew Bonema. He's number 2.
I have it.
On the, yeah, so we just placed a statement of defense on plea of guilty into O courts. Matter comes on for a pretrial hearing today. Ready to proceed.
Full name, Matthew Joseph Bonema. Mr. Bonema, I'm looking at a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. Tells me you're 39 years of age. You've been through the 12th grade. Any problem at all reading, understanding the plea form and the process? If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which, since this is a gross misdemeanor, could be up to 364 days in jail and up to a $5,000 fine. With that in mind, as to 1 count of theft in the 3rd degree, alleged to occurred within the city of Yelm on February 28th of this year, 2025, how do you plead guilty or not guilty? To make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. That being said, I'll listen to your attorney for a recommended sentence.
Just recommendation of a suspended sentence, and just ask the court to follow it.
Mr. Bonema, that's I will follow the recommendation. Do you have anything you'd like me to know? We all make mistakes, and the point is we need to learn from them instead of repeating them. And you're about to be in a position, I think, where you're going to have some obligations to see to, and that becomes difficult when you're in a courtroom. 364 days, suspended for a year on the condition you have law-abiding behavior, $250 probation fee. You can pay that over time. That's the least of my concern. Stay out of trouble. That's the condition upon which jail time is suspended. Take a minute to review and sign the judgment and sentence. Mr. Bonema, I'm going to wish you the best of luck. Thank you for your patience. I hope everything goes well with your situation that you referred to earlier. I want you to get a copy of today's paperwork at the window to your left as you exit the courtroom. Look it over carefully, and if you have any questions about what it means, give Mr. Haverko a call. Good luck to you. Take care of yourself.
Mr. Hominger.
Good morning, sir. Full name Christopher J. Humminger.
We've just placed into Oak Court's a statement of defendant on plea of guilty. He's gonna enter a plea to the interlock charge. Upon the court's acceptance of that plea, the city would move to dismiss the suspended driving third degree charge. Ready to proceed?
Mr. Humminger, I'm looking at a statement of defendant on plea of guilty to one count of operating a motor vehicle without ignition interlock when required to have that by the Department of Licensing. Plea form tells me you're 35 years of age. Any problem at all going over the plea process with Mr. Haverco? Had any questions? Were your questions answered? And again, I accept the plea. You give up the rights in paragraph 5, no trial, no appeal, just a sentencing, which could be up to 1 day short of a year in jail and or a $5,000 fine. You realize that. As to, with that in mind, as to one count of operating a vehicle without ignition interlock within the city of Yelm on May 13th, 2025. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. Mr. Haverco, with regard to sentencing?
Oh, it's an agreed recommendation, Your Honor. Would ask the court to follow it.
Do you have anything to add, Mr. Hatfield?
Nothing to add, Your Honor.
Mr. Humminger, anything you'd like to tell me? Anything you think I should know? No. This is one of those hoops you have to jump through that the Department of Licensing puts right in front of you, and it's a pain, but the longer you have good driving, these things just go away after a while. I'm going to follow the recommendation. 364 days suspended on the condition you have law-abiding behavior. That includes don't drive unless licensed and insured, and pay a $250 monitoring fee in the meantime. Any questions at all? That again, are you still under ignition interlock conditions? Is that still? Yeah, I'd jump on that. Looking at the judgment and sentence form. Humminger, I'm signing that. It's the electronic signature takes longer than a pen on a paper. That concludes the matter. What I want you to do is get a copy of today's paperwork at the window outside and to your left. Look it over carefully, and if you have any problems, questions at all, give your attorney a call. We wish you the best of luck, and again, the sooner you get the ignition interlock in the required period of time, the sooner that'll be behind you. Good luck to you. Any questions? Mr. Humminger, good luck.
Next matter, the 10 o'clock is Levi Showeiler. The matter comes on for a pretrial hearing on a reckless driving charge. Parties have had an opportunity to talk about the case. The city is going to move to amend to, I believe, speeding too fast for conditions. 150.
Morning, sir. Full name, Levi Carl Showeiler. This Showeiler, the city is moving to amend the charge from a real serious criminal offense to a simple civil infraction. You know what happens when you get convicted of reckless driving? Your license is suspended, there's a fine, there's a possibility of a lot of jail time. With regard to the infraction, too fast for conditions, I don't have the statutory citation at this time for that. 46. I'll assess a 100. Do you admit the infraction? I'll impose a $150 fine. That's there's two things here. One, your enlightened self-interest. Serious offense like reckless driving, that'd just murder your insurance premiums or your whoever's paying for the insurance. And two, you know, try to remember that driving a car, a vehicle on the roadway is probably the most dangerous thing, very well likely the most dangerous thing you ever do in your life. So take care of yourself, drive safely. And there's more and more people out there that are angry and driving like it, but hey, just let it go, stay out of trouble. I've talked to more than one person that flipped off the wrong person and had a gun pointed in their general direction. That's just, yeah, be safe, okay? Signing a order on the infraction. What I want you to do is get a copy of that at the window, Mr. Showeiler, and look it over. Have any questions? If you have any trouble making the payments on the fine, let us know. We can certainly deal with it. You don't want it to go as a failure to pay to the Department of Licensing. That just adds to the difficulty. Your attorneys put you in a real good position here. Real significant reduction to a real serious offense. Take advantage of it and drive carefully, okay? Good luck to you. Any questions of me? Take care of yourself. Be well.
Welcome. Take care. Alexandria, why don't you come up?
Is this Alexandria Johnson?
Yes.
Ms. Johnson, good morning.
Putting a motion to continue into O courts here.
How far out would you like
She
to
actually
go?
has made progress on an evaluation, but she didn't tell the evaluator the magic words of deferred prosecution. So they didn't do that. And so anyway, I actually spoke with the treatment provider yesterday. I think it's all straightened out. So we just need to reset it so she has enough time to have a new appointment with her evaluator for the more specific purpose of a deferred prosecution. So just continue like ordinary course.
July 17th or 31st? What works?
Well, the later or after that.
Yeah,
Let's say
31st.
4 to 6
Right
weeks.
now with the 4th of July,
Oh.
these providers are going to be
Right,
busy or no
right,
get
right.
out. Ms. Johnson, yeah, resetting the matter to July 31st. Stay in touch with your attorney and we'll see you back here then. Any questions at all?
Sure.
Would you call me after? I did talk to Tony.
Yeah.
And she said that the thing that I did is for the evaluation, even though
I just need a physical evaluation.
So it just
Recommends
wouldn't
deferred prosecution. It doesn't mention deferred prosecution.
So I mean, to go to different,
No, no. They all do these things. Just need to go back to her and say, we need to get deferred prosecution evaluation.
See, Donnie is, Miss Curlin, she.
Okay, that should be enough.
We'll wait till Dan calls it, whenever he wants
All right,
to
pretty good.
run it up and do it. Ms. Johnson, thank you for your patience. You take care. Have a good day.
I'd like to just take one thing out of order, just because I'm still working on some other things. If we could turn to the 1 o'clock calendar and Ms. Scheid, why don't you come up? She was thinking her court time was 10:30 and
Is this Stephanie Scheid?
yeah.
Good afternoon. For the record, Stephanie, middle initial A, Scheid. Ms. Scheid, citation I have alleges that on or about June 25th, you committed the offenses of theft in the 3rd degree, criminal trespass 1st degree. Now, each of those is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf at this time, and he's going to represent you throughout the course of the matter, should you be indigent and require his services.
Thank you, Your Honor. Would stipulate probable cause, ask the court to enter not guilty pleas on both charges.
Plea of not guilty preserves your rights. We're going to set the matter for a pretrial on August 14th at 10 a.m. You'll get a copy of the order setting that hearing. Want you to stay in touch with Mr. Haverco. He'll need to have your contact information.
You have a phone number? Yeah, so just before you, the judge will sign the order, and then before you go, if you want a paper copy, which you should get one, just stop up at the clerk's window, and she'll print out today's orders.
Order is now signed. You get a copy of it at the window. Stay in touch with Mr. Haverco. His contact information will be in today's order. Any questions of me? No. Conditions of release or stay out of trouble. Law-abiding behavior. Take care.
Well, I still have, what's your name?
You do have somebody on
Yeah,
Zoom.
give me one. Oh, we do have someone on Zoom?
Yes.
Perfect. Yeah, let's go ahead and take that up.
Good afternoon, Ms. Curlin. This is docket numbers 7 and 8. Curlin, you're now unmuted. Are you able to hear me?
Yes, I can hear you just fine.
Here, thank you. Your attorney's in the courtroom, Mr. Haverco. I'll turn to you for the status of the matter.
Thank you, Your
Docket
Honor.
number 7 and 8, page
Yeah, thank you, Your Honor.
9.
We've got two matters, both part of the same incident. So 2 cases, both matters come before the court for a pretrial hearing, violation of order restricting contact and a suspended driving third. There's a statement of defendant on plea of guilty within the O courts. I anticipate she's going to enter a plea to the order restricting contact. Upon the court's acceptance of that plea, city would then move to dismiss the other case, suspended driving 3rd degree.
Good afternoon, ma'am. Is your full name Catalina Michelle Curlin?
Yes, it is.
Ms. Curlin, do you disagree at all with anything Mr. Haverco just said?
No, we did speak about it and I was in agreement with what he has stated.
I'm looking at a statement of defendant on plea of guilty to 1 count of violating a order restricting contact. Plea form tells me you're 28 years of age. Did any trouble at all reading, going over the plea process with Mr. Haverco?
No.
If you had any questions about what it meant to plead guilty to a criminal matter, was any question you had answered fully?
I did have questions for him and he did answer them to the fullest extent, and I do completely understand.
Hey, thank you. Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing which could be up to 364 days in jail and up to a $5,000 fine, this being a gross misdemeanor. You realize that?
Yes, I understand.
With that in mind, as to one count of violating the conditions of an order restricting contact within the city of Yelm on April 19th, 2025, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, I do.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. I'll turn to Mr. Haverco for any recommended sentence.
It's an agreed recommendation. She is in treatment. I think she's calling from if I'm correct, I think she's calling from a treatment facility. So
That's
to
correct.
the extent the court could maybe take that into consideration with respect to the imposition of financial obligations. She's essentially kind of an indigent situation at this moment.
Do you have anything to add? Ms. Curlin, is there anything you wish to tell me? You don't have to say anything, but if you want me to know anything about your situation or the case, now's the time.
Yes, the protected party is actually the father of my unborn child. I am almost 5 months pregnant with his daughter. I am currently in a treatment facility as Isabella House in Spokane, and I am working very diligently right now to graduate the program and just turn my life around at the moment. I understand that I have made mistakes and I'm attempting to, right some of those mistakes that I've made and just turn a new leaf in my life.
Ms. Curlin, thank you very much. We all make mistakes, and the thing is, we have to learn from them. I'm glad to hear you're doing what you're doing over there in Spokane. That's going to be a great help towards getting on a great path in life. I'm going to impose 364 days in jail, suspend all of that on condition you have law-abiding behavior. I'm not going to impose any fine at all. I'd rather have you devote your attention and resources to the recovery process that you're now in, okay?
Okay.
We'll be sending you a copy of today's paperwork, and look it over carefully, and if you have any question at all, give Mr. Haverco a call, okay? And with that in mind, what the DWS third charge issued on the same date, April 18th, that charge is dismissed. Any questions at all, Ms. Curlin?
No, sir.
I'm going to wish you the best of luck. You take care of yourself and be well.
Thank you.
You're free to sign off. I think that's it. I signed the firearm order. I don't think that's of any concern of hers. Mr. Mold, good morning.
So this is Mr. Quick.
Good afternoon, sir. Is it Kevin Quick for the record?
Just for being late, I thought it was at 11.
If you're here, that's the important thing. No problem.
And we placed a stipulated order of continuance in Oak Courts and ready to proceed.
Mr. Quick, I'm looking this document, stipulated order of continuance, SOC, as they call it. It's a contract, is what it is, between yourself and the city, negotiated by your attorney. Have you gone over the agreement with your attorney? Now, if you violate this agreement and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction. You don't want to go there. You have a chance to get this case basically dismissed, but it's up to you to do that. Law-abiding behavior is the significant condition here. Probation fee of $250. That's for monitoring. If you have any trouble making the fine payments, let us know. We can deal with that. Payments will be set at $25 a month. First payment due August 3rd. Yes, that can be taken care of at the window. Important to realize you've got to stay out of trouble now, and that would include the instant offense. Any protection order that's in effect, very important to religiously make sure you abide by it. Signing off on the agreement, Mr. Quick, what I want you to do is get your own copy of that at the window, and later today when you have a chance and not in a courtroom, read it over. And if you have any questions about anything that's contained in it, give Mr. Haverco a call, okay? Any questions of me? You're only due back in court if there's a problem. That's as long as you're abiding by paying the fine, 25, and staying out of trouble. We'll simply review the file and dismiss the case at the end of a year without you having to reappear. So yeah, and so it is, just in case something happens, always a really good idea to keep a current address on file. If you move, let Mr. Haverco or the court know that, okay? Mr. Quick, good luck to you. Take care. Mr. Mold, good morning. You solemnly swear or affirm that you will accurately translate from Spanish to English and English to Spanish all that is said during the course of this hearing? Yes, sir. Thank you. Mr. Haverco?
Thank you, Your Honor. So this is David Navez Vasquez that comes before the court this morning for a pretrial hearing on a driving under the influence charge. I've had an opportunity to discuss the matter with the assistants of the court interpreter to discuss the matter with the defendant. I believe the parties have reached an agreement. That being a stipulated order of continuance. The matter to be continued for 2 years. On the driving under the influence conditions. And upon his compliance, the matter would later, at the end of the stipulated order of continuance period, be amended to the charge of negligent driving in the first degree. We'd also like to stipulate that to consider this DUI a no test case. A no test case.
So amended.
So ready to proceed.
Hi. Good morning, sir. Full name David Navez Vasquez. Do you disagree with anything Mr. Haverco just said? You have a contract here with the city. Over the next 2 years, stay out of trouble, especially no alcohol-related offenses. Pay costs in the amount of $990.50. Get a drug and alcohol evaluation within the next 30 days. Now, that might not be possible given the season we're in. But stay in touch with your attorney and do the best you can. You fulfill the conditions. In 24 months, this charge will go on your record as a negligent driving first degree. That's a big difference between a DUI conviction. Now, if you violate the agreement, we'll have a hearing based on the police reports. Which would almost certainly result in a conviction for DUI. I'm going to wish you the best of luck. You won't need to come back to court unless there's a problem here. So just be safe. Let Mr. Haverco know if there's any change in your address or contact information. Any questions of me? I'm signing off on the agreement. What I want you to do before you leave is get a copy. At the window that way. Look it over carefully. And if you have any question, give Mr. Haverco a call. Any questions of me? I'm going to wish you the best of luck. You take care of yourself. You've got an excellent resolution of this case. Please take advantage of it. Good luck to you. Ray, good luck. You take care. Have a good 4th of July. Stay safe.
I'll need just a minute to prepare a petition for deferred prosecution on Angela Mayo. So just take a few clicks. here.
I just noticed there's and should have noticed earlier, there's a couple of civil infractions with
Oh.
Mr. Neves.
Oh, that's right.
Is there-
Would the city just consider dismissing those? Okay,
So ordered.
thank you very
Docket
much.
number 8, citations dismissed.
Where's the-
I should have noticed that. but-
Yeah, I saw it and I should have mentioned it too.
We're not perfect. We just strive to be.
Okay. On the petition, there's actually not much to fill out. It's a little bit to fill out on the order. So sign here. Sign. Where is the order on deferred prosecution? Oh, it is? Oh.
Is there an evaluation?
Yes, there is. Yeah, let me just handle it now. I just wanted to put in I think you're supposed to put in the
Okay.
order. Led by Northwest Resources. Sign here one more time. I wasn't sure, does she still need to, I didn't have her physically sign the petition. Does she need to do that? I mean, not the petition, but the evaluation. I don't know if the court wants her, needs her to do that. Sometimes they
fine.
provide a signature line on the evaluation.
A lot of these forms I just don't like. But hey, this is fine. If we'll go over it on the record, if there isn't a place to.
She signed the petition and the proposed order.
Yes, the petition is signed and the presented order,
Yeah.
It says that it was served on the defendant, so yeah, she's gonna get a copy of the. I've reviewed the eval, so anytime you're ready to proceed.
Oh, yeah, we're ready to proceed,
Okay,
yes. And we're on record, so this is, Your Honor, this is.
Angela Lynn
Yeah.
Mayo,
Yeah.
confirm that for the record.
Yeah.
Ms.
Matt-
Mayo, I've got this petition here for a deferred prosecution, and I've reviewed the proposed findings in order. Let me say this. You've chosen the more difficult path to follow. With the obligations that are now imposed on people in one of these programs, I think it would be somewhat easier to just take whatever medicine you have to take for a conviction and go on with life. But you've chosen to say, hey, look, I can be better in my life than I've been. I can do a lot better. And it's going to be kind of rough, but you've chosen to walk that path. I'm going to sign off on the order granting the deferred prosecution. I take it you're fully aware of the obligations you have. Complete the treatment. They're recommending an IOP, intensive outpatient in reval. I'm familiar with the agency. It's a good one. And if they recommended it, that's what's necessary to deal with the issue. And you've gone over, you've seen and read the eval, and yes, I take it. Let's take that to heart. I'm granting the deferred prosecution, and of course the worst thing here is oh boy. They won't let me sign it until I enter a where is that in the oops. Usually they have that. They usually, there we go. They usually have it.
Yeah, if you just click on the calendar and then just.
Got
select
it.
today's
July
date.
3rd. Got it. The order does say report to probation. We don't have a probation. This will be with the bench probation. We just monitor it, and we'll get treatment reports from Northwest Resources. Ms. Mayo, this is I'm going to wish you the best of luck, and you have my admiration for choosing to approach this problem as you have. All I can do at this point is wish you the best of luck, and the costs. Mr. Havico, I think I'm not inclined to order any costs in the matter. Does the city have any thought on that? I'd rather have you devote your resources to getting through this. That's going to be enough. And the Department of Licensing requirements as well. You're going to need money for that. So I would just as soon.
Thank you, Ron.
I've signed off on the order. Now, what I want you to do, Ms. Mayo, is get a copy of there's a lot of documentation here, and a lot of it's just boilerplate, but I want you to look it over carefully, get a copy at the window and look it over. And if you have any questions, give Mr. Haverco a call if you would. Any questions of me? Again, be well, take care of yourself, and I wish you the best.
Thank you.
I thank you.
Yeah. You're welcome.
Which number is it? Number. We do have somebody on telephone.
Yeah, I was just gonna tell the court, Mr. Jordy Cisneros Chavez has appeared. He's here. The docket, or the calendar indicates that we should be using an interpreter. I think he's left, right? Was he here? Oh, okay.
He's present.
Gotcha.
Good afternoon, sir. Is your full name Jordy Cisneros Chavez?
Yes.
Mr. Mold is under oath and he'll translate in this matter. Looks like the problem is treatment and or drug usage.
So, Your Honor, he would agree that he has been out of compliance. He's trying to do what he can to get back in compliance. He indicated he's going to church, also going to the gym. So I think for him, that's part of working his way back to compliance. Right. What's your next step of treatment? Are you supposed to be in treatment? And then you're supposed to apply for treatment.
I think it's just gonna be a reset. It sounds like.
Oh, he indicates he's going to restart treatment at a place called Conseco on the 11th.
We did receive a June 17th document from them.
Okay.
Yes.
Okay.
City have any input in this matter? That's and the request is?
The request would be to, assuming the court wants to obviously track this, to reset it with enough time sufficient for him to re-engage and commence or
August
restart with
14th.
that treatment.
Mr. Cisneros, that's relapses. That's part of dealing with the situation. That's, what I'm gonna do is this, note the violation. I'm not gonna impose any sanction on you. Some courts would have you serve some jail time. I'm not gonna do that. I'm gonna reset the matter to August 14th. If Mr. Mold is available, and
14th of August.
August 4th, yes, August 14th, I'm sorry. I shouldn't think and talk at the same time. Mr. Cisneros, I'm going to wish you the best of luck. You take care of yourself. And the most, the important thing here to me is I haven't seen or heard of any indication of any reoffense, any new problems, and that's. But we want to make sure that continues to be the case. Hence, leave the sometimes alcohol and drugs are not the best friends. Signing an order resetting the matter to August 14th. I want you to get a copy of this order at the window. Give your attorney a call if you have any questions. Any questions of me? Yeah, I'm going to wish you the best of luck. Don't give up on yourself. Just do the best of you can. And none of us are perfect. Take care of yourself. Mr. Moe, thank you. You take care. Have a good 4th.
Oh, okay. Oh, wow. Okay. This is, by the way, standing next to me, I think are you as well? This is Brennan Wing's mom.
Oh, okay, yes.
She said she just kind of randomly decided to check the jail roster and apparently showing. Oh.
He's in the.
Oh, okay.
Where is he? In the Squally?
Yeah.
Oh, boy.
So.
On our warrant. Oh, that's. Oh, swell. Well. Let's talk on number 11.
So.
On page 13th.
As far as the case today, do we want, I mean, as to this case, do we want to reset it and track it with something else or?
Any idea how long, what he's looking at, how long he's going to be there? He was just cited and booked on a new charge, so we don't really have any idea. What now? I'll call later today. Oh, okay. Let's reset it to the 17th. The 17th. Let's reset. We're going to reset this case to the 17th at 1. Now I'll be talking to him. Apparently, he's being held in custody, and I'll be calling and I'll release him, and that'll be his court date on the new charge as well. 17th at 1. Hey, Ms. Wing, thank you very much. You take care.
I have 3 people in the courtroom that I mean, a couple I've never had contact with, so if I can squeeze talking to them today, I will. It's 11:20. I may have enough time to.
If you want to go off record for a bit,
Yeah,
we'll
just see if
certainly.
I can-
We're going to be on off record until Mr. Averco's had a chance to talk to everybody here. On time? Oh, you got paperwork over here that was. Back on record with the pre-trials. Mr. Haverko, I'll defer to you for the order in which
Yeah, thank you.
any cases are called.
Yeah, thank you. Okay, Mr. Amadon, why don't you come on up? See, that was on, I think
And this is?
This is Mr. James Amadon. It's the first item on the 11 o'clock calendar.
What? James Owen Amadon.
Yes, sir. Let me have him sign a plea statement here.
Oh, got it.
Matter comes before the court for pretrial hearing on a theft charge. I anticipate he's going to enter a straight plea guilty to the charge. We placed a statement of defendant on plea guilty into O courts, ready for your honor to inquire.
Mr. Amadon, let me affirm for the record, James Owen Amadon. I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. Plea form tells me you're 42 years of age, you've been through the 12th grade. Any issues at all reading, understanding the plea form and the process you're going through to enter a plea to a criminal offense?
No.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing which could be up to 364 days in jail and or a $5,000 fine, given that this is a gross misdemeanor. With that in mind, as to one count of theft in the 3rd degree, alleged to have occurred within the city of Yelm on April 21st, 2025, how do you plead guilty or not guilty?
Guilty.
Do you make that plea of your own free will?
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 on the form does satisfy the factual elements of the offense. That being said, Mr. Haverko, with regard to recommended sentence.
Well, it's otherwise an agreed recommendation. He would like me to ask the court to consider waiving or reducing the financial obligations. He is working, making about $24 an hour. But I think what he's impliedly saying is that maybe based on his expenses in a situation, money is still nevertheless pretty tight. So anyway, that would be his request on the fine.
City, have any input? Mr. Amadon, anything you'd like to tell me? You have a right to tell me anything you think I should know or want me to know.
The only reason I'm low on funds is because why we continued this court to this month instead of last month, I had to bury my dad. That's basically everything I had to say about.
That makes sense, and that's just part of the circle of life. We bury our fathers, and one day our offspring will bury us. That's just the way it is. Mr. Amadon, I'm going to follow the recommendation in part. 364, all suspended on the condition you have law-abiding behavior. Stay out of trouble. We either learn from our mistakes or we're condemned to repeat them, and don't want that to happen here. I'm not going to impose any fine. I sometimes feel reluctant to impose that burden on people. I've signed the judgment and sentence. Mr. Amadon, I'm going to wish you the best of luck. What I want you to do is go to the window outside the courtroom to your left, get a copy of today's paperwork, look it over. Any questions you might have, ask Mr. Haverko, okay? Good luck to you. Take care of yourself. Thank you, sir. And you as well. And you as well.
Next matter is going to be Mr. Byer.
Mr. Byer, come on up. Is it Matthew Byer?
Yes.
Good morning, sir. Turn to your attorney for the
We placed in no courts a proposed stipulated order of continuance, matter to be continued for 12 months. On the condition that he commits no further criminal law violations, pays a $250 court fee, $25 a month, at the end of which time, if he complies, city will move to dismiss.
Mr. Byer, did you disagree with anything Mr. Haverco just said on your behalf? I'm looking at this SOC, stipulated order of continuance, which in reality is it's a contract, an agreement between yourself and the city negotiated on your behalf by Mr. Haverco. If you fill your side of the bargain, this case is the charge will be dismissed 12 months down the road. What you're agreeing to do is most importantly, stay out of trouble. No criminal law violations. There's also a probation monitoring fee of $250. That's the least important thing to me. If you have trouble making the monthly payments on that, let us know, we can deal with that. Now, in return for the agreement, as it says within it, you've given up your rights to go to trial, no appeal, they're gone. Therefore, if the city proves that you violated the agreement, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction with the possibility of jail time. You have a chance to get a crime of dishonesty, if you will, dismissed. You need to take care of that. Before you leave, get a copy of the agreement at the window outside the courtroom to your left. Look it over carefully, and if you have any questions at all, give Mr. Haverco a call, okay? In the meantime, I wish you the best of luck. You take care of yourself.
Yeah.
Mr. Amadon has a question.
Your Honor, this is Mr.
Mr. Amadon,
This
yes.
came back. Apparently, the fee was included in the. I think Your Honor, on Amadon, I think you ordered no fee.
I did.
There's a fee. in the document.
It was that's on me, my fault. Let's delete it.
Oh. Okay. Yeah, they'll fix it. Yeah.
Can I do it? Can I do it? I think I'm allowed to. Well,
We can. Oh, no modifications. Oh, okay.
Take a look at that.
Anna, do you want to look for a second?
Yeah.
We're just gonna submit a motion to continue. So I can try to talk to your. Yeah.
Mr. Adams, we're preparing an amended judgment and sentence, which I'll sign, and from which, yeah, that's on me. I should have noted that that was not deleted from the form.
I appreciate it.
That's one of the troubles I have with these check the box forms.
Okay. Okay, so I need to get that too.
Amended JNS signed. What now? Okay, got it. Done.
And Mr. Amadon, why don't you come up here, just right here, and just sign on this pad. Cool.
Yeah.
That's good. Thank you.
Mr. Amadon, thank you. You take care of yourself. Back to the dashboard.
Okay, this is Tanner Lunsford. And we put into Oakcourts a motion for a continuance, ordinary course. We're waiving speedy trial.
How far out would you like to go?
Ordinary course, like 6 weeks. No.
Lunsford, at the request of your attorney, we're going to set the matter out, say August 14th, maybe. August 14th. I'll sign an order to that effect. Mr. Lunsford, what I want you to do is get a copy of the order at the window and we'll see you back here then. Any questions at all?
No, sir. Yes, we'll see what I can do. Yep. All right. Yep. Thank you. See you.
Mr. Lunsford, thank you.
Cool. So I think.
We have one individual
Did
left.
Tina Dawson ever? Could be.
Could be
her.
Tina Dawson.
Yeah. Right.
We have an iPhone.
Probably her.
Somebody is present on an iPhone. You're muted. If you'd unmute yourself and tell us who you are.
I'm sorry, Your Honor. I didn't realize I didn't type my name in. This is Tina Dawson.
Ms. Dawson, good morning. Mr. Haverco's in the courtroom. We'll address your matter at this time.
Matter comes up for pretrial for a DUI case. It's been taken a while. She's in Montana. She did call me yesterday, and I told her that in case the court asked, the court might ask why it's taken so long, and so she did gather some information if the court wants to know. But she indicated to me she has signed all the releases she is supposed to sign with her treatment places, that she's had treatments and evaluations in Montana, with the idea then, along with a release of information with Freedom Recovery, the next step is to have an evaluation with them. I don't think that's occurred, but I think she's making progress towards that. So unless the court has further questions on that, we would just ask to reset the matter
How far out?
in the ordinary course, say 6 weeks. Tina, do you have any idea at all, when an evaluation might occur with Freedom Recovery? That's kind of the next step, I think.
Well, I'm honestly a little bit concerned about why my information is not being received by Freedom Recovery. According to the place here where I had my evaluation, they sent over my information on May 27th, May 22nd, and then they're also resending it over today, July 3rd. The representative at Freedom Recovery said that he's going to give me a call if he receives my information. There are 2 different fax numbers that they can receive information. I was not aware that on my ROI, I didn't put both fax numbers. I only put one fax number. So I have a new ROI being sent out to me to where they can fax to both numbers, just in case if there's some sort of a hiccup there. And then also an ROI so that they can mail my information to Freedom Recovery. For some reason, not allowed to email it. But that's what I have so far. It just seems to be hiccups in receiving the faxes.
And Tina, the only thing I would suggest, as a matter of last resort, if there's some way you could make this happen potentially, is that if you could somehow get your hands on hard copies of all the evaluations from Montana and just stick them in your own, make copies yourself and just hard mail them to Freedom Recovery would be another, potential approach. Just, I don't know if you could get your own copies of all the reports, like I said, then you could be the one to transmit them and not rely on these agencies. Just a thought.
I think that's a great idea, and I will look into that later on today and see if I can do that. sounds like that would be a quicker way to get, the information over to Freedom Recovery so that we can get that evaluation going.
So, yeah, so the defense request is just to reset, it's taken a while, but,
Hey, better late than never.
you know,
Ms. Dawson, as long as you're doing the best you can to get things together and where they need to go, hey, that's no problem with me. Let's reset the matter out to, August 14th? Not gonna work?
I'd kick it out the next one. The next, which would
Yeah.
be what they did.
Yeah. I appreciate your patience, Your Honor.
Hey, Ms. Dawson, the important thing here is we haven't heard anything about any reoffense. And sounds like you're doing well there in Montana. So we're resetting the matter to August 28th. We'll send you a notice of hearing, and we'll talk to you then, and we'll see where things are at that point.
All right. Thank you so much.
Dawson, thank you for appearing. You take care.
You as well. Bye-bye.
Mr. Haverko, I guess that's it for the.
That's it, yeah. All that remains are the FTAs. Yeah.
I just want to address the no-shows at this point. Let's start with number 4 on page 8, Jacob Hazlitt.
My notes reflect he never had a phone, so I have not had any information to contact him. And I've not heard from him.
So ordered, 1,000 cash or bond.
On Russell, on the 11 o'clock on Russell Chenier, I had spoken with him at some point. That's why I had placed an SOC in Oak Courts, and I received no communication from him in the last few days as to his not appearing today. I'd have to look up to see when I last spoke with him.
Yeah, there's an SOC in
I mean, I spoke with him on like July 1.
Day before yesterday, Monday or Tuesday.
Yeah, that's my notes.
Well,
I mean,
since you've been in contact, I have no problem.
yeah,
Note
I
the
mean,
non-appearance for
yeah.
speedy trial purposes. We'll
Yep.
reset to ordinary course.
Right. And the next one is Bethany Crow, and let's see here. Bethany Crow. Yeah, I spoke with her on yesterday, and I thought we were gonna, enter a plea. So she didn't advise as to not showing up. So I guess I'd ask for the court to note the non-appearance for speedy trial purposes and reset the defense request.
Any objection from the city? With no objection from the city, that's exactly. We'll note the non-appearance for speedy trial purposes and reset with notice.
On Charles Jarrett, I spoke with the guy. I don't think he has his own phone. He might be like the brother. It's like a sister and brother, and they live kind of nearby each other. So I spoke with a person who answers the phone, and they're telling me they'll try to get a message to him to let him know I called when they see him. I've never heard back, so I've never actually talked to him. So.
Cash or bond, so ordered. That goes with the territory.
Let's see. Look at my notes on Robertson. I spoke to him on 6/29.
Mr. Robertson,
Yeah, Mr. Robertson, he apparently had court in Thurston County and said that by way of global resolution, the Yelm was going to dismiss. I said, I hadn't heard anything about that unless the city has behind my back. So I said, Yelm's a different jurisdiction, so I don't think they're dismissing it unless there's some agreement I haven't been told of, so.
and he's got a
Anyway,
bond
so-
posted here.
But based on that conversation, I had anticipated he was gonna show up and likely enter a plea today, and so I haven't received any information subsequent to that conversation with him as to him not showing up, so I don't have any. So I mean, I guess I'd ask the court to note the FTA and reset it, since I did speak with him on June 29th.
Well, unless we notify the bonding company of the unexplained failure to appear by statute, we kind of lose the bond.
So what's the rule on the bond?
Yeah, well, if we don't notify the bonding company of an unexplained, it's 10/16, I can't remember. That's we lose we can't forfeit unless we notify them within a period of time of I think it's within 10 days.
Well, I mean, I'm sure the defendant would.
Is this explained or unexplained?
Unexplained.
It seems unexplained.
It seems unexplained to me. It's it's in the scheme of things relatively minor charges.
Right.
It's, not the crimes of the century.
No.
Okay, city moves to forfeit, reissue in the same amount.
And on the next matter is Michael Scott. My notes reflect that the number I had been provided, and I tried it several times, the phone number he provided me it's not working. So
No
it's
surprise.
not, it's disconnected, so I can't.
No surprise.
I've had no contact.
No surprise at all. So ordered, 1,000 cash or bond.
And I think we already dealt with Brendan Wing earlier, so.
Yep. Good afternoon. You're here for an arraignment. That's your first appearance after getting a criminal citation. Call you up one at a time, deal with your case. But first I need to let you know you have a right to have a lawyer represent you at all stages of any criminal proceeding. Mr. Haverco is here. He is our public defender. He'll enter a plea of not guilty on your behalf today, and he'll represent you throughout the course of your case, should you be indigent and request his services. Plea of not guilty will be entered today, and all that does is preserve your rights pending a pretrial conference, which we'll set for a later date. Purpose of that is to determine whether or not you can resolve the matter by agreement. If you can't, you have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. If you have any question at all about your rights, what you're charged with, either ask Mr. Haverco or myself. First, going to call the matter of Samuel Newman. Is that your full name, sir? Samuel Newman? Citation alleges that on or about March 23rd of this year, 25, you violated the terms of a probation order or of a protection order. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll ask Mr. Haverco to enter a plea on your behalf, and after that, if you give him your contact information.
Stipulate probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty preserves your rights. Mr. Newman, now a condition of release is law-abiding behavior that includes abide by all orders of protection, whether you agree with them or not, okay? Give Mr. Haverco your contact information. We're going to set the matter along with another case you have that's on an SOC status with this court. Have you given Mr. Haverco your?
Yeah.
Okay, good. What I want you to do, and everybody, as you leave, go to the window outside the courtroom and to your left, get a copy of today's order and read it over. Give Mr. Haverco a call if there's any questions, okay? Mr. Samuel, Mr. Newman, that concludes the matter. Get your order and we'll see you later. Thank you for appearing. David Arlotta? David Arlotta does not answer. Thomas Atkinson does not answer. Kimberly Bertram? Hey, ma'am, if you step forward, have a seat. Now, Ms. Bertram, what I'm going to say to you is probably going to apply to quite a few other people in the courtroom. Mr. Ratfield, this is docket number 3, page 14, DWLS 3rd being the citation.
The city's moving to
Ms. Bertram, the city has amended the charge from the criminal offense of driving a license suspended or revoked to the 3rd degree. Conviction would bear the possibility of up to 90 days in jail and up to a $1,000 fine. They've amended that to a civil infraction. The difference is with an infraction, and that in this case would be no valid operator's license on your person when you were cited. You don't plead guilty or not guilty to an infraction. You admit it or deny it. If you admit it, I'm going to impose a $150 fine. If you deny it, you're entitled to a contested hearing, which we'll set at a later date. Any question about anything I've just said? You admit or deny that you drove without a license on your person on June 28th? I'll assess a $150 fine. Now, most importantly here, do you know what you need to do to reinstate your license?
Yes, it is.
Good. I would make that a project in your life. We live in a world where it's pretty hard to get around without a driver's license. So I've signed the order setting the $150 fine with payments, usually at the rate of $25 a month, first payment August 3rd. Now, if you have trouble making the payments, let us know. We can certainly deal with that. Any questions about anything that just happened? I'm going to wish you the best of luck in getting relicensed. And what I want you to do is get a copy of today's order at the window. Ms. Bertram, thank you for appearing. You be well and take care of yourself. Dontavius Bickerstaff. does not answer. How about Eric Brown? Eric Brown does not answer. Brianna Capps. Ms. Capps, come on up and have a seat. Is your full name Brianna K. Capps? Ms. Capps, you are also cited with driving a license suspended, revoked in the third degree. And the city is likewise moving to amend your charge to the civil infraction of no valid operator's license on your person. You may have heard what I said to the previous individual. So the question is, bearing in mind a civil infraction, there's no possibility of any jail time. You either admit it or deny it. You don't plead guilty or not guilty. You admit or deny that you didn't have a valid license on your person when you were cited on June 17th. 150 it is, Ms. Capps, and then I'll ask you the same thing. Do you know what you need to do to get your license reinstated? That was, yeah, I'd make that a project in life. I'm signing the order, setting the fine at 150. I've now done that. Ms. Capps, what I want you to do is get a copy of the order at the window. And good luck to you. You take care of yourself. Thank you, ma'am. Mariah Clevenger? Does not respond. Joseph Day. Good afternoon, sir. Full name Joseph Everett Day. Mr. Day, the citation alleges that on or about June 16th, 2025, you committed the offense of violating a protection order. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Day, a plea of not guilty does preserve your rights pending a pretrial, which we're going to set for August 14th. The conditions of release are stay out of trouble, law-abiding behavior, and that especially applies to no contact orders and contact information.
All right. I'll be calling you.
Mr. Day, that concludes the hearing. Yes, definitely get a copy of the order at the window. Shelby Dorman. Does not answer. Patrick Elder. How about Robert Ferguson? Good afternoon, sir. Full name Robert Douglas Ferguson. Citation issued on June 17th, 2025, alleges that on that date you committed the offense of driving while under the influence of intoxicants. That is a gross misdemeanor upon conviction. Maximum penalty would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Ferguson, the conditions of release are law-abiding behavior. Don't drive unless licensed and insured. Don't drink and drive at all. Any officer asks you to take a breathalyzer, you're to do so. Any question about that?
I'll be calling.
And of course, the other conditions are stay in touch with your attorney and be back here on the 14th of August.
Sure, thank you.
Don't forget to get a copy of the order at the window. Jennifer Flowers does not answer. Julio Alberto Gulila Madrid. I'm going to mispronounce that name, I'm quite sure. And for that, I apologize, sir. How do you pronounce your last name? Okay, thank you. Citation alleges that on or about June 24th, you committed the offense of driving a license suspended or revoked, third degree. City may have a motion in this case as well. And by now you probably know what that motion is, to reduce it to a civil infraction with a fine. You admit that on or about June 24th, you were cited without a license. I'll take the nod as an admission. Now, do you know what you need to do to reinstate your license? I would start with the Department of Licensing. Start with the Department of Licensing. They'd be able to tell you. Unpaid traffic tickets is one of the usual ways of you get your license suspended. Sign an order setting the matter at $150. $25 a month would be the payments. First payment, August 3rd. Any questions at all? Sir, I'm going to wish you the best of luck in getting reinstated. Okay. Good luck to you. Thank you for appearing. Ashley Gimbert. Brandon Kenyon. Mr. Kenyon, your citation likewise is DWLS third degree, and city may have a motion in your case, and does. The charge is no longer a criminal offense. It's a civil infraction of no valid operator's license on your person. And you know what the drill is. If you admit it, it's $150. If you deny it, you can have a contested hearing at a later date. Admit or deny. I'll take that as an admission. Now, Mr. Kenyon, do you know what you need to do to get your license back? I'd make that a project in life. Signing the order. Having done so, Mr. Kenyon, go ahead and get a copy of the order, and good luck getting your license reinstated. Jonathan Lane. Mr. Lane, good afternoon. An attorney has appeared on your behalf. Yes, is she, by any chance? She's not on Zoom. Was she going to be here?
She was supposed to be on Zoom.
I'm sorry, Mr. Lane, we can't call your matter until we have your attorney appear.
Can I step on with her call?
Oh, sure, sure, absolutely. And we'll come back to the matter. Larson Maisar, M-A-I-S-A-R. Good afternoon, sir. Full name Larson Maisar. Did I pronounce that right?
Yes, sir.
That's there's a way to mispronounce a name. I'm going to do it. Citation alleges that on or about June 26, he committed the offense of obstructing a law enforcement officer in the performance of his duties. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you, and he will enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to court to enter a not guilty plea.
So noted. Mr. Maisar, a plea of not guilty has been entered on your behalf. We're setting the matter for a pretrial on August 14th. In the meantime, give Mr. Haverco your contact information. Be back here on August 14th. And in the meantime, law-abiding behavior is the condition. Okay. Any questions at all?
call him. Yeah, just go to the clerk and she'll give you a copy of your paperwork.
Oh, boy. Donnie, I have a little bit, I'll just keep trying. It's. Can I try to sign it?
Okay.
And it just comes up there.
And mine just.
And then it
keep
just
So try going out.
oops. Maybe just refresh it.
Yeah, I think it's gonna keep. Yep, that's what just happened to me. Okay.
Huh. Now what do I do?
I'm hoping it'll fix it.
Malfunction. And restart it, see what happens. Yeah, that was weird. Never had that happen before. Sometimes they make me sign it twice.
Yeah. I think
On the
there's
screen is.
something wrong right now.
When is it otherwise?
Yes, that's true.
Ah, there we are. Now we'll see. We'll go back and see if we can. It's trying to open. I get the little circle. There it is. Hold my breath. Ah, it went line signature. Oh, wonderful. Joseph Murray in the courtroom. Joseph Murray does not respond. How about Ashley Ramirez? Kirk Reynolds. Jeremiah Ray. Mr. Ray, good to see you. Thank you for appearing and talking to me. Go ahead and have a seat if you would. Full name Jeremiah, middle initial M. Ray. Mr. Ray, you were cited. We went through this on the telephone, but I got to do it in person. On June 29th, cited for disorderly conduct and obstructing and resisting. The first two are gross misdemeanors. The last one is a simple misdemeanor. I'm going to have Mr. Haverco enter a plea on your behalf at this time. He'll do that.
Thank you, Your Honor. Stipulate to probable cause, ask the clerk to enter not guilty, please.
Mr. Ray, a plea of not guilty preserves your rights. What we're going to do is set the matter for a pretrial. That gives you a chance to talk to Mr. Haverco about your matter and resolve it by agreement if you can. If you can't resolve it by agreement, you got a right to go to trial if you choose to do so. I want you to give Mr. Haverco your contact information.
Looks good. Okay. Okay. All right.
Mr. Ray, I want to thank you for appearing. And what I want you to do is go to the window outside the courtroom and get a copy of today's order and stay in touch with Mr. Haverco. Any questions of me? Hey, thank you for appearing. That concludes the hearing. We'll see you back here August 14th. How about Sarah Richards? Good afternoon, ma'am. You were cited with driving while license suspended or revoked, third degree. City may have a motion in your case and does. The charge is amended to the civil infraction of no valid operator's license on your person. If you admit that, Ms. Richard, I'll take that as it's a $150 fine. I'm sure you know that by now from listening. I'm signing an order to that effect. What I want you to do is go to the window, get a copy of that, and if you have any problem making the payments, let us know. And I would make getting your license reinstated a project. If you're not sure what you need to do, what I want you to do, just go to the Department of Licensing. They'll help you out, okay? You take care of yourself.
Thank you.
Thank you, ma'am. Christina Russell. What a surprise. Jolene Sharer does not appear. Paul Segura. Hey, good afternoon to you. Is it Paul Anthony Segura? Mr. Segura, the citation alleges that on June 21, 2025, you committed the offense of theft in the third degree, gross misdemeanor, the maximum penalty on conviction, 364 days in jail, and or a $5,000 fine. I'll have Mr. Haverco represent you in this matter as well. He'll enter a plea on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty preserves your rights.
We still represent another case or?
And that's the July 17.
Let me double check.
Mr. Segura, you have a pre-trial already set for July 17th. We'll calendar this along right alongside that.
I do, Your Honor. Yeah. Will be able to represent you in this matter or?
Oh, yes.
Yeah, they're just different matters. So you still at the 480? Okay, got it. Sign on this pad.
Mr. Segura, that concludes the matter. Get a copy of the order at the window outside. We'll see you back here July 17th. You be well. Take care. Absolutely. Have a good one. Thank you, sir. John Shedeker. Good afternoon, Mr. Shedeker. You also were cited with the, sounds like a broken record at this point, DWLS third degree, suspended but eligible for reinstatement. City does have a motion in your case, amending it to the civil infraction. Now, the civil infraction, you know what the deal is there. If you admit it, it's 150. If you deny it, you're entitled to a contested hearing. Any questions? Hey, that's great. If you've reinstated your license. Yeah, you were cited on June 20th. So what matters here is did you have it at that time or not? No, I want to congratulate you on that. And the penalty, it's still 150. If now, as you know by now, it's kind of easy to lose your license and a little bit more difficult to get it reinstated. Now that you have it back, make sure you keep it, okay? Sign the order. Go ahead and get a copy of that at the window and hey, be careful out there on the road, but be safe. Stay legal. Take care. And you as well. Jaden Taylor. Lester Trummert. Ah. Good afternoon, sir. Full name Lester Clayton Trummert. Citation alleges that on about June 17th, 2025 and applicable dates, you failed to pay B&O tax. That I believe is a misdemeanor with a maximum penalty of 90 days or 1,000. In any event, I'm going to appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Yeah. I mean, everything will be taken care of in 30 days. I sold the business.
Yeah, oh yeah, just give me your number just in case.
Yeah.
What's your number?
253.
Okay.
905. 55.
Is that like a cell?
Yeah, that's.
Okay. And. Oh. Sure. Silence tab. Okay, let's go.
Or.
Oh, I'll call you. I'll just call you. Or text you.
Pre-trial set for August 14th. I said, you told me I was dead. I was walking. And the last 5 items on the calendar are Robert Williams. We'll address that. Okay. And I believe that that would appear to be it, except for well, well, are you?
What's your name? Oh, you're for traffic? Yeah. Oh. Yeah.
There are 2:30? Sure, as may as well. We're back on record. I'm going to call the matter of Yelm versus Christina Marie Ruiz. Come on up, have a seat. Do you want moral support? They can pull up a chair alongside.
No, he's good.
Yeah.
Ma'am, you were cited for speeding. Now you've asked for a mitigation hearing. Now we can certainly do that. A mitigation means a reduction in the amount of the fine. You're also entitled to a deferral. A deferral is a way of keeping it off your record. With regard to a moving violation, you're allowed to do that once every 7 years. Now, It looks like you have an excellent record. So if you want to keep it excellent, ask for a deferral, I'll grant it, and we'll defer the case. Any question about that?
Yeah, the deferral, they said something about you take a class and then, or something.
That's part of it. Usually a deferral involves costs. You know, that we forget about the 217 face amount of the ticket. Costs, so that would be in the amount of $100 is what we charge. And also require that within the next 4 months, you attend traffic safety school. It's something you can do online, and I think it costs $40. But if you do that online and file proof of it and don't have any other infractions over the next 4 months, the ticket is dismissed. Would you rather, do you want to do that?
Well, I should, because if I just pay it, then it stays on my record.
Yes. If you, what I would do is the 217, I would reduce the 217 down to 150, and you would still have your deferral if you needed it in the future.
So, but if you just reduced it, is what you're saying, it'll still be on my record then?
Yes, if I just reduced it, the amount of the money, it would be on your record as a committed infraction, a speeding ticket. If you defer it, it doesn't go on your record if you successfully could complete the deferral.
Yeah, because I just take a class then, right? And then that's.
Yes, pay us $100 and attend this online class. I think we can give you the information. That'll be in the order.
Okay, I'll do the deferral.
You'd rather do that?
Oh, no, then, no.
You don't want to defer it?
No, let's just lower it.
Just reduce it?
Reduce it, please.
Okay, I'll reduce it to 150.
Thank you.
That way you still have your infraction deferral available to you.
That should just affect like my insurance and stuff.
We're setting it's 150. You can pay that at the rate of 25 a month.
Okay.
First payment due August 3rd.
Okay.
I'm signing the order at this time. Ms. Ruiz, if you'd get a copy of the order at the window. Any questions at all? Give us a call.
Okay, thank you.
Good luck to you. Drive safely out there.
Thank you.
You take care of yourself.
The window's out there.
Yes, out there and to your left.
All right, thanks for speaking.
Ron, record, I'm gonna call a little bit earlier, an infraction hearing. Somebody is here for an infraction. Who was cited? And you brought moral support? If the both of you want to come up and sit at the council table, you're more than welcome to. And yes, ma'am. And if you'd give me your name. Brittany Duncan. Ms. Duncan, you were cited for speeding on March 27th. Take a look at the ticket here. You've asked for a mitigation hearing. That means you want me to reduce the amount of the ticket. You're also entitled to do what they call a deferral. Do you know what that is? A deferral is a way of keeping it off your record. Your record indicates you don't have anything other than this. You can keep it that way. Every court does deferrals differently. The way I do it is hold the case for 4 months. If during those 4 months, 1, you don't have any more infractions. 2, pay costs of $100 to the court. 3, attend online a traffic safety school. We give you the information for that. That's I think $30, $40. How did you remember? Oh, really? We have the information on that.
Yes, we have the information.
Now, you're only entitled to defer a moving violation once every 7 years. You can do the same with a non-moving violation. I don't know why people would want that, because non-moving doesn't affect your insurance like a moving does. Any question about anything I just said?
No, I don't think so.
Do you want to do a deferral, or would you want to just want the ticket just reduced?
We'll do the deferral,
Pardon?
the deferral. Yes.
I think that's a good idea. Keep it off your record. Yeah, but I have to ask people to speak up. I'm afraid 50 years of chainsaws, outboard motors, motorcycles, et cetera, that's Ms. Duncan, I'm just setting the payments at 25 a month over 4 months. Some courts do a deferral for a year. 4 months is enough, I think. But a good record keeps your insurance premiums real low. And I always try to remind people, driving a car is probably about the most dangerous thing you're ever going to do. That's especially with the anger that we have out there on the road. I drive up to Bellevue and back every other week, and it just gets more and more difficult. Any questions at all?
No.
I've signed an order to that effect. You don't need to reappear. We just simply check your record 4 months from now. If you've done everything you need to do, the traffic safety school, the $100, no tickets, we'll dismiss the citation. It does not go on your record. I've signed the order. Now you can get a copy of that, and I'll want you to do that. Go to the window outside the courtroom and to your left and ask. Any questions, Ms. Duncan? Yes, sir. Yes, 25 a month, and that's in the order. First payment due, I think August. It just says period of 4 months, $100. It's not in there, but yeah, if you want to break it up, 25, as long as it's all paid within at the end of 4 months. That's it. Again, get a copy of the order and happy motoring. Keep your record nice and clean.
Thank you.
Ms. Duncan, thank you. And thank you for your help, sir. That we can go off record. And maybe we got somebody else here. Sir, you are? Yep, you're here. You asked for a contested hearing with regard to a expired tabs and a speeding ticket.
Yes, sir.
Come on up and have a chair. You bet we'll take that matter now. And for the record, your name is Zachary Plaschek, is that how you pronounce that?
Close enough, Palashek.
Now, that's, you've asked for a contested hearing and we can certainly give you one. Another option is a deferral. You can defer a moving violation once every 7 years. And that keeps us off your record. That's a surefire winner. If you have a contested hearing, you might win the speeding ticket. That's haven't heard any of the evidence yet or seen what the city has to offer. But expired registration, that's a non-moving offense. Any question about anything I just said?
One question about that would be if, out of curiosity, if I go with the contested hearing, am I able to still take advantage of the deferral program after the fact, or is it kind of a now?
No, it's kind of, I don't want you to.
Okay, ultimately, I mean, I would like to take advantage of the deferral program because ultimately my main goal would to have it come off of my record completely, yes.
Yes.
Because I do have a Class A CDL and I ultimately
Oh,
like to
wow.
be a lineman, so I definitely don't need that going on my record. It was an honest mistake on my part, excuse me. So I would like to, if I can do the deferral program, does that take the payment away entirely for the ticket, or do I still pay the ticket and it comes
Yes.
off my record?
Yeah, if you pay, if I find you committed the infraction and it goes on your record. So if you defer it, it doesn't. Why don't we do this? I'll defer the speeding ticket.
Okay.
And only with a deferral on, if you have a CDL, I'm not allowed to reduce the amount of
The actual ticket.
I'll have to set the costs on that ticket at $268.
Which is fine. I'm okay with paying the $268. As long, ultimately my goal would be to just, as long as it doesn't go on my record, doesn't hit my insurance.
That's what we're
doesn't hit
doing.
anything like that.
I'll
that's what I'd
dismiss the expired registration. Have you taken care of that?
Not quite yet, sir, because to be
But
honest,
you're working
it's-
on it. Okay.
in a sense, it's kind of like a peaceful protest to a degree, because I do not agree with having to pay for $80 tabs. Because I do remember voting for $20 tabs back then, so that.
We will defer it, but the costs are going to be $268, 4 months, and traffic safety school. That'll be in the order.
Okay, for the traffic safety school information with that, is that, how long is that, or?
Oh, it's done online and it's what, a couple hours?
Okay,
It's not a recurring seminar yet.
Okay, just wanted to be clear on that too. And then from my understanding as well, for a deferral program as well, how that works is if anything else happens within a year, pull over for speeding, anything like that.
4 months.
Or, only 4 months.
With me, it's 4 months. A lot of courts, it's a year.
Okay.
A lot of courts, it's a year. I think, to me, that's too long.
I appreciate that, man.
Sign in order to that effect.
Which, I mean, ultimately, I don't plan on getting pulled over at all for that anymore, so.
I'm a firm believer in better late than never. That's the ticket is the hassle that's involved in insurance premiums, et cetera, et cetera. It's just not worth a couple of minutes. And yeah, I like speed as well as the next person, but that was many years ago. Mr. Plaschek, sign an order to that effect. You can get a copy of that at the window outside the courtroom and to your left.
All
Good
right.
luck to you.
Thank you,
Take
sir.
care of yourself.
You too.
There's a couple late shows for the 1 o'clock. One of which is here, the other one's in the restaurant. I don't know if you're on.
I think probably just reset to the next, Garrett, we can take it now if you want. I'll leave it up to you. If you want to deal with it now, we'll need Garrett in here, I guess. Who is this?
This is Mr., I think it's Bickerstaff.
Mr. Bickerstaff, he's early in the, yes.
Yeah. Yeah, I showed Garrett who they were and he seemed to think whatever the court wants to do as far as conditions of release.
Yeah, go ahead. We're on record. Good afternoon, sir. Is your full name Dontavius Bickerstaff? Mr. Bickerstaff, the citation I'm looking at alleges that on or about June 23rd, 2025, he committed the offense of loitering, drug-related activity, a gross misdemeanor with a maximum penalty on conviction of 180 days and or $1,000 fine. Also cited for paraphernalia, that's a misdemeanor, maximum penalty on conviction to be 90 days and or a $1,000 fine. I will appoint Mr. Haverco to enter a plea on your behalf. He'll represent you throughout the course of the matter, should you see fit.
Thank you, Your Honor. Would stipulate to probable cause as the court to enter a not guilty, please. Do you have a phone or anything?
Oh, yes, sir.
What's your phone?
213.
Okay. Okay.
2193.
Okay.
Mr. Bickerstaff, conditions release, of course, are law-abiding behavior and no consumption of non-prescribed drugs. Citing an order to that effect, had ordered a warrant, no warrant will go out. When you leave the courtroom, I want you to get a copy of today's order at the window. Order is signed. See you back here on August 14th. And that's in the order.
Okay.
Yeah.
Thank you.
Thank you, sir. You take care. Thank you for appearing.
Why don't you come on up and what's your last name? That's right.
And this is?
This is Ms. Jolene Scherer. It's number 26. Page 18.
I dealt with that one in custody as well.
Oh, okay.
Full name Jolene, middle initial N, Scherer. Ms. Scherer, citation issued to you on June 23rd, alleges you committed the offenses of controlled substance, knowing possession of it. Maximum penalty for that would be 180 days and or a $1,000 fine upon conviction. Same way with loitering, drug-related activity. You're also cited for use, delivery of paraphernalia. That's a misdemeanor with a maximum of 90 days and or 1,000. You're also cited for a pistol I've reviewed the police report and I don't find any probable cause for that.
Okay.
You're cited for pistol unloaded in a vehicle. There is a reference to a 45 caliber in a bag but there's no reference to whether it's loaded or unloaded.
Right.
So if it was loaded, that'd be an offense, but if it was unloaded, that's not an offense.
Right.
But go ahead, I'll appoint Mr. Haverco to represent you, and he's going to enter pleas to the remaining 3 charges.
Right. As to counts 1, 2, and 4, would stipulate to probable cause and ask the court to enter not guilty pleas. And do you have a phone number at all or a cell phone or anything? Okay. Okay. Is that the other, is that the same? Oh, okay. And you guys share it? Okay. Okay. And I'll be calling you folks before your next, court date.
Sure, thank you for appearing. Conditions release your law-abiding behavior. Stay out of trouble. No non-prescribed drugs. And get a copy of today's order if you would at the window outside the courtroom and excuse me, to your left. Any questions at all, ma'am? Concludes the hearing. You're free to leave.
Okay, take care.
We have somebody else.
Roy? I'm not sure what the hour. Do you know what time the court was? 8:30 today. Oh, it's a traffic ticket. Okay. This is Mr. Roy. He's.
That's an infraction.
Yeah, one of the infraction cases. Yeah.
Excuse me, Stephen Kent Roy. Mr. Roy, you've asked to mitigate a no insurance ticket. Looks like failure to have registration and a defective vehicle license plate lamp. I'd be glad to reduce that, especially the insurance ticket, man, 400 and that's way
I got insurance now.
great. Well, tell me what happened here. How'd you happen to get pulled over and cited?
How did I get pulled? I was just driving down the road and the cop right behind me called me, said I had a defective light out on my license plate.
And you have insurance now.
I do now.
Well, 559 is way too much. Let's reduce it from 559 to 150. And the other ones, failure to,
Sign that.
that was the problem. You just didn't sign it.
Yeah.
I'm going to dismiss that one. And then the defective license plate lamp. Did you get that repaired? Probably a good idea.
Yeah.
Okay, good. Let's reduce that to 100. So it's of course 250. That's better than 849, isn't it?
A lot better.
I'm going to sign an order to that effect, Mr. Roy. Yeah, that's all an officer has to do it. I've heard it said you can't drive 100 feet without committing some offense or another, but always make sure, yeah, the headlights working, taillights working, license plate light working. No reason having an excuse to just get pulled over. Signing an order, Mr. Roy, to that effect. You can pay that at 25 a month, starting August 3rd, if you wish.
Okay.
Order is signed. You can get a copy of that at the window outside the courtroom to your left. Happy motoring to you and take care of yourself. Have a good Fourth. Thank you, sir. On record for the no shows for the arraignments, starting on page 14, docket number 1. David Arlotta, probable causes previously found on him when he was released from custody for knowing possession of a controlled substance, paraphernalia, and loitering drug related. 1,000 cash or bond. Next one, Thomas Atkinson, find probable cause for the issuance to him of a citation for driving a license suspended or revoked in the 2nd degree, 1,000 cash or bond. Number 4 did appear. Number 5, Eric Brown, cited for DWS 3rd, amend that to no vol 2 and FTA it, and his infraction on the next page, docket number 6, to FTA that one as well. Mariah Anna Marie Clevenger, I got the docket note and consulted with the prosecutor on that. I'm moving to dismiss that without prejudice. That we go to docket number 10, DWS 3rd, and docket number 11, DWS 3rd, amend each to no vol 2 and FTA. Next would be Jennifer Flowers, docket number 13, amend to no vol 2 and FTA, that one as well. Ashley Gimbert, probable causes previously found when I spoke to her in custody for theft 3rd, 1,000 cash or bond. That brings us up to Joseph Murray. I found probable cause for the issuance to him of theft 3rd, 1,000 cash or bond. Ashley Ramirez, found probable cause for paraphernalia, loitering drug related, and a false statement. When I released her from custody, she was in custody, 1,000 cash or bond. Next one, docket number 22, Kirk Reynolds, amend DWS 3rd to no vol 2 and FTA. Christina Russell, I thought I should have kept her. Probable cause previously found, 1,000 cash or bond. Jolene Scherer is now taken care of. Brings us up to Jaden Taylor, docket number 30 and 31. Amend DLS 3rd to no vol 2 and FTA it, and FTA the no insurance ticket. On Robert Williams, probable cause has previously been found on all 5 cases. Do we have to issue 5 warrants?
Yeah.
1,000 each. And that, I think, is that including all the infractions.